Good evening, everyone. Welcome to this webinar this evening. For those of you I haven't met, my name is Joanne Frederick. I'm president of the board of Stop MPRP Inc. We have expecting quite a crowd today, so we're going to get started. We have a lot of information to cover, and I'm going to introduce Carolyn in a moment. And we're thrilled to have her take the time to answer some questions and talk about what's coming up with the Maryland Public Service Commission and the intervention process and the CPCN and all of the things that none of us have had to do before, but are learning very quickly about. So very excited about that. Carolyn's done a lot of work with her presentation to try to answer as many of the questions that we've received in advance as part of the presentation. And then we'll have some additional time for questions after her presentation. So we put those questions in the Q&A box at the bottom of your screen. And I've got Betsy McFarland and Allison Earlbeck here as well, and they'll help us kind of monitor and manage those questions for when we get time for Q&A. Couple of things to start. One, we will not be discussing Stop MPRP Inc.'s specific strategy with the intervention at the Public Service Commission, and that hopefully is for obvious reasons. We are recording this. We will share this webinar after this evening, and we want to make sure our strategy stays close hold. If you will be at the event on Saturday at Black Locust, I will be there all day, and I'm happy to have individual conversations with folks about some more details. And then secondarily, if you're with another organization across one of the three counties, Stop MPRP Inc. is happy to collaborate with you with your intervention, et cetera. So we can talk about those things as well. But I just wanted to let folks know that again, the strategy will not be kind of part of what we're talking about today. Now, without further ado, I would like to introduce Carolyn Elefant. She is a highly regarded and very experienced attorney in energy matters, and we are very fortunate and thrilled to have her represent Stop MPRP Inc. and all of our members at the PSC with this intervention. She has a fabulous presentation prepared for us. Hopefully we'll shine some light on this process and what we can expect. And we're planning for a very robust and a very effective intervention for this project to stop this project from happening. So without any further ado, I'm going to turn it over to Carolyn. Carolyn?
Thanks, Joanne. Good evening, everyone. I'm just going to bring up my presentation if you give me a second here. Let's see where the screen is here. Okay, can you see just the screen? Okay, I'm going to go into presentation mode. Just give me one more second. Get this set up and then I'll say some opening words. So anyway, what I'm going to talk about tonight is how to understand the Public Service Commission process for issuing a certificate of public convenience and necessity. That's the acronym CPCN. So we'll be using terms like PSC for Public Service Commission, CPCN for Certificate of Public Necessity and Convenience. These are just some of the acronyms that unfortunately in a matter of months are going to become very familiar to you if you're not already familiar with them. So I've practiced before the Maryland Public Service Commission for at least 2 decades, and also before the Federal Energy Regulatory Commission, ordinarily representing landowners and ratepayers and consumer interests. And so this type of case is very much along the lines of cases I've handled before. And I hope that I can answer all of your questions. So we're just going to go ahead and get started with the presentation. I have a little bit of a cold, so I may be drinking my tea throughout, and hopefully my voice will hold out. So anyway, these are the topics that we're going to cover. We're going to briefly go into how we got here, how this PSC review process works, how impacted parties can participate, what the PSC standard is for approval, and then what happens after a CPCN is issued or maybe denied, the appellate process, and what happens with eminent domain. I know there have been questions about that too, and the eminent domain process is also connected to the CPCN process, and so there's some overlap there. So anyway, here's the TLDR, too long didn't read, version of how we got here. PJM, which is the regional transmission operator, is responsible for planning transmission in the Maryland, Virginia, the DMV region, and also other states in the Mid-Atlantic. They initiated what's called a regional transmission expansion plan, and they discovered that there was a need for additional transmission. Studies, I don't know what the PJM report actually said in terms of the studies, but basically the Office of People's Counsel and other sources have said that this project is really being built to serve Virginia's data center load, which is growing. And that's something that's no secret, that's no news flash. You know, you can see how extensive the data center population is in Virginia. So what happened is PJM reviewed it received different proposals from different transmission companies that are members in this regional transmission organization. And it selected the one that was offered by PSEG, called the Maryland Piedmont Reliability Project. And that's a 70-mile, 500 kilovolt interstate transmission line. So that's where PJM's authority ends. PJM's role is limited to planning and identifying a party that's going to implement that planning. Once the line actually has to be sited, it has to be done. That has to be done by the states that are impacted, in this case, Maryland. So what Maryland law says is that if you want to construct a transmission line that's bigger than 69,000 volts, you have to get what's called the Certificate of Public Necessity of Public Convenience and Necessity, the CPCN. If you don't have a CPCN, it means that you can't start construction. And if you don't have a CPCN, and this is really important and should allay some concerns, no CPCN means you cannot exercise eminent domain. Now, there's some issues even if you have the CPCN as to whether a company can exercise eminent domain, but it's very clear that before a CPCN issues, eminent domain is completely and entirely off the table. So if any representative from the company is coming to you and telling you that eminent domain is going to happen next week or next month, it's completely untrue. The CPCN process, as we're going to talk about, is going to take a significant amount of time. Go to the next slide. So we're going to talk a little bit about how the review process works. COMAR is the acronym for the Maryland regulations. They're available online for anybody who wants to take the time to read them or put themselves to sleep at night. And this is the section so that you can check the different sources. That's the other thing that's really important to do in this proceeding. Don't take anybody's word for something. There are a lot of interests that are involved in either advancing this project or potentially trying to advance the project, who may tell you things that are not entirely true. You always want to go to the source, check the regulations, check the statutes, speak to the leadership at Stop MPRP to see if they can answer your questions, because there's a lot of fictitious information that kind of comes up in these proceedings that can cause problems for landowners, even if it's well-intended. So anyway, the first thing that a company has to do when it wants to get a CPCN is it has to fill out an application. And this application is not like an application for applying to college or an application for a driver's license. This is a huge tome of information. So the first thing the company has to do is it has to talk about what the need is for the project, impacts on system reliability. It has to explain cost effectiveness. It has to give a detailed description of the transmission line, including the location. So for those of you who have felt like to date, there really hasn't been very much information about where this line is going to run, the application should make that clear. There'll be maps and there'll be drawings and there'll be diagrams showing where it's going to run through and what the impacts are on environment, recreation, archaeology, historic sites. These factors are all listed in the regulations, and the company really has to adhere to them to the letter, because if it doesn't provide this information, its application could be dismissed. Now, of course, it can refile its application, but dismissal is a delay, and delay in these proceedings is always a good thing. It always benefits the impacted parties. Another thing that's really important is the company has to describe each alternative that they considered and also state what the cost is of each of those alternatives and the reason why those alternatives were rejected. And so that's another avenue where I know parties have been trying to get information to figure out what, why this route was decided or was chosen over others. That information has to be provided in the application. And then finally, the company has to supply environmental information and studies to support the impacts that it discusses in the application. So as you can see, this is, it's not just a box checking exercise. This is a robust piece of information that's probably going to run thousands of pages. And so, like I said, what does the application look like? It's an enormous multi-part document. One of the things that's interesting about the application is that in addition to these reports that have to be filed, the company is also going to file what's called pre-filed direct testimony from different witnesses. So I'm sure most of you have seen court proceedings where a witness comes into court and their attorney asks them questions about the particular case, and then they get cross-examined. The way that these things work at the Public Service Commission is that the testimony that you're putting on in support of your case, which is called the direct testimony, that's not something that you provide at the hearing. That's something it's typed out like a transcript and it's pre-filed. And so what the applicant does when it submits its application, it has to have people testifying as to the truth of each portion of that application and also explain what the information is in that application. And so you're going to see when you get this application, there's probably going to be testimony from maybe 8 or 10 or 15 witnesses. Sometimes these companies, you know, they want to put the entire payroll on the application and have ratepayers pay for it. So, so you see a lot of testimony. But what I would expect in this case is there would probably be testimony from an engineer talking about what the need is for this project and what the reliability is. You'll probably see testimony from some environmental experts or scientists who are going to be talking about the impact on each of those features, criteria, if it's impacting water or wildlife or trees or forests. You'll have witnesses testifying on that. You'll probably have a witness who's testifying on the alternatives and why one line was chosen over another. And these witnesses can either be from the company, they may be PSEG employees, or they may be outside consultants. Companies have different practices. Some of them rely heavily on outside consulting companies. Some of them rely on their staff. We just won't know who those experts are until the application is filed. Like I said, the application will also have many studies and reports in it as well. So once the application is filed at the Public Service Commission, this is done electronically. You'll be able to review it or download it from the Public Service Commission website. Copies of the application are served on the council and the council in the counties that are impacted. So here it would be the council members in Carroll, Baltimore, and Frederick County, and also the General Assembly representative who represents those different impacted counties. All of the state agencies that have jurisdiction over some part of the application, so over environmental issues, over aviation issues, they will also get copies of the application. Now, with each landowner or owner of adjacent land where the lines will be located, so if your property is either in the direct path of the transmission line or adjacent to the path of the transmission line, you'll get notice of the filing. You will not get a copy of the application, but you will be notified that it's filed, and presumably this notice will tell you where you can get a copy of the application. And then the notice is also published in newspapers in impacted counties, and it's also circulated on social media. And so all of this is designed to kind of get the word out to let people know that a project is being proposed. A project like this one is so large, it's been subject to so much media that it's hard to imagine at this point that people don't realize that it's going through and it might impact them. So, you know, as long as you're if you're here tonight, you're probably going to figure out very quickly or that, you know, get a notice of, you're going to know when the application is filed if you've taken the time to participate here tonight. But that's the thing, once the application is filed, if you're a landowner whose property goes through the path, or if you're adjacent, you want to be looking out for some kind of paper notice, probably sent in the mail, maybe by email. I don't know exactly what format it would take. Okay, so now we're up to intervention. So once the application is filed, that kind of opens up the deadlines for filing either comments or interventions. And the commission will set the deadline. It's usually around 20 to 30 days. It could be longer because this is a very large proceeding. So let me explain first what an intervention is. An intervention makes you what's called a party to the case. And so that makes you somebody who has a stake in the case. It gives you certain rights to be able to challenge the decision at the end and to be able to submit information. I'll talk a little bit more about some of the rights of an intervener versus a commenter in the next slide. So in order to intervene, you have to be impacted by this project. And so if you file a motion to intervene, you have to explain how you're impacted. You have to explain that your interests are not represented by any other party in the proceeding and that your issues are material and relevant to the proceeding. The way the statute works, the statute governing intervention, which is MDPUA 3-106, it allows for intervention, but it also it tries to avoid the problem of duplication of interest. And so, as I said, one of the grounds for denying an intervention is if your interests are already adequately represented by other parties in the case. So that might be an example, if you're in the community, say you live in Carroll County, and the transmission line's going through, you don't like it, but your house and your property is not going to be impacted, and you live 20 miles from the site, and so there's really no chance that it's going to be rerouted to your property, but you want to say something about the project, and you file a motion to intervene, your motion might be denied because there are so many other parties who are directly impacted who also oppose the project. And so arguably your interest in opposing it is already represented by another party. So that might be a situation where you would be limited to filing comments and where your intervention could be denied. And the other thing has to do with your issues being relevant and material. If you were to file a motion to intervene and say that these power lines are a conspiracy, start raising like conspiracy theories about them and crazy issues that are just not relevant to challenging the line, you would probably also find that your intervention is denied. So those are kind of the two restrictions or limitations on the ability to be able to file the motion to intervene. Now, the other thing with intervention is this is a legal proceeding. This is, it's called a quasi-judicial proceeding. So a lot of the regulations or the requirements that apply to representation in a court also apply to the Public Service Commission. And so for that reason, just like in court, any individual can represent themselves. The same is true at the PSC. If you're intervening on your own behalf, if you're a homeowner whose property is in the transmission line and you're intervening to represent just yourself and your family, that's fine. You don't need an attorney to do that. But just like in court, if you own an LLC, even if it's a solely owned LLC just by you and there's no other members, the LLC is considered a separate entity. So if your LLC were sued in court, you would have to hire an attorney. Even though you're the only member of that LLC, you're not permitted to represent that LLC because that would constitute the unauthorized practice of law. And the same rules govern in the Public Service Commission. So if you're representing, if you own a farm that's organized as a corporation or a limited liability company, you will need to get an attorney to file an intervention on behalf of your company. If you have formed some sort of association with your neighbors and you want to intervene on behalf of the association, you will probably need an attorney to represent the interests of that small association that you put together with your neighbors. So that's a potential cost of intervening in a proceeding is our legal costs, depending on what the nature of your interest is and how you are organized. So these are just some of the pros and cons of intervention versus sort of, I guess, I wouldn't say there's necessarily a con. There's a few cons to intervening, and then there's a few just neutral considerations. And these are just things to consider. This is not, I'm not giving legal advice, and this certainly does not represent any position that STOP is taking. These are just some considerations that you might evaluate as you start thinking as to whether you might want to intervene or not. So the first thing that intervention does is, as I said, it gives you the rights of a party in a case. So you preserve your right to challenge an adverse decision if it issues. So if the commission were to issue a CPCN and this property and this transmission line winds up bisecting your farm and destroying it, that would probably be a decision that you might want to appeal. Also, intervention gives you the opportunity to present evidence and testimony and question witnesses, so you can have a more active participation in the proceeding. And that's something an intervention would allow you to do. That's also something where you're probably going to feel more comfortable with an attorney, because the attorney is going to be familiar with the process of cross-examining witnesses and submitting documents. You also would be able to receive all of the filings in a case if you intervene. If your property is substantially impacted by a project, it gives you an opportunity to raise arguments. And the thing that's very important to understand, if there is a substantial impact on your property, is that you may forfeit the ability to raise those arguments if you don't raise them in the PSC proceeding. So if the CPCN issues and the case goes to eminent domain, and this transmission line has run right through your farm, and you tell the court, the company should have rerouted it, the court is not going to listen to that argument. The court is going to say, if you thought it should be rerouted, you should have raised that issue in the Public Service Commission proceeding. So again, if you're substantially impacted by the project, that might be a consideration for intervening, and if you are going to suffer significant financial consequences. And then, like I said, sometimes these proceedings, the commission doesn't always issue a decision on a CPCN. Sometimes the parties, or many of the parties, may agree to a settlement, and the parties that don't agree to the settlement will want the ability to challenge the settlement. And if you're an intervener, you can challenge the settlement. So what are the flip side of the motion to intervene? Well, first of all, like I said, it can be costly if you need an attorney. So you want to do a cost-benefit analysis and figure out, if your interest is impacted significantly enough to justify the cost of hiring an attorney. Your intervention may not be that effective if you don't have a budget for experts. If you're going to intervene and just comment on the case from your own perspective versus filing testimony, the comments that you file are going to be treated just like any of the other comments that are filed, because if you don't intervene, you can still just file comments in the case. You just don't get those rights to appeal or the rights to participate in the evidentiary hearing before the Public Service Commission. And like I said, in this next point, you always have an opportunity to submit written comments and to speak at public hearings. The public hearing is different from the evidentiary hearing, and I'll talk about the difference between the two processes in a subsequent slide. And then there's also a possible risk. I know that there are kind of two schools of thought. Some people believe that the more interveners you have, the more leverage you have. It's going to look scary to the PSC. They're going to think there's a lot of opposition. That really isn't true. The PSC knows there's a lot of opposition to the project just based on the number of people showing up for these town halls or these meetings with the company. So the PSC is well aware that there's opposition to the project, and the fact that the opposition comes from comments versus interventions doesn't change the level of that. And there is a concern that if so many people are intervening just to make a statement, that these proceedings can be very unruly, and eventually other parties who have bona fide interests, who have farms or who have homes that are 2 feet from the transmission line, may not be able to have an opportunity to intervene. So those are things to consider also. If it's so important to you to intervene because you feel strongly about this, but you're not personally impacted, you could be potentially making it more difficult for your neighbor who's right underneath the transmission line to intervene and protect their interest. So these are all considerations to take into account. I can't give advice on these, but these are some of the factors you want to take into account when you're making that decision. So there were a couple of questions using this term passive intervention. There's no designation or definition of a passive intervention in the regulations in the PSC regulations, but you can be a passive intervener. And by that, what that means is that you would file a motion to intervene. You would say, I'm impacted by by this proposed project in this way. I'm intervening solely for the purpose of receiving filings in the case and preserving my rights in the event that I am impacted in the future. And then essentially what you would do is, you wouldn't submit testimony, you wouldn't cross-examine witnesses. What you would do is, as the parties file interventions, I mean, as the parties file testimony in the case or file documents, you might send a letter in and say, I'm an intervener, I join in support, or I adopt the testimony filed by this organization. And so that way, you're letting your views be known, you're keeping a foot in the proceeding, but you're not causing any type of disruption. And so that's kind of what the definition of a passive intervener is. And that's something that you wouldn't need an attorney for unless, as I said, unless you're in the situation where you have a business that's impacted by the pipeline that's organized as a separate entity, or if you represent a small organization, then you would still need the attorney even for this so-called passive intervention. So that could potentially be a solution also if you're considering intervention, but you don't necessarily want the cost or the burden of putting together testimony and sitting through hearings every day. So some of the guidelines for intervention, I've provided some materials to stop MPRP, and I'll leave it to their discretion as to what they can, what they'll decide to share. But generally speaking, if you're going to file an intervention, you want to be very specific about what the impacts of the project are on your property. So you might want to include photos of your property, maps of your property. You might want to include a declaration or an affidavit, which is essentially a statement from you speaking personally about how much the property means to you, why you purchased the property, how it's been in your family for a long time, how it's going to be disrupted or destroyed by this proposed transmission line. The most important thing with interventions, I think, and also this goes for comments too, is to really focus on what you know. I mean, you may read about how this project, about how one alternative was more expensive than another, or how the project might impact wildlife or archaeological resources. If that's something in your expertise, then it's helpful to make comments on that. But otherwise, the most powerful interventions are the ones that focus on what the impacts are that you're the most familiar with. I mean, those are the ones that are the most compelling and heartfelt. And especially for landowners and property, the story of your property is something that's uniquely personal to you. And it's the kind of thing that people don't know. I mean, most people can figure out that a transmission line that goes through a forest is going to affect the wildlife that live in the forest. It's almost self-evident. But a lot of the stories about property are really not known except to you and your family. And those are the kinds of things that if you bring that information out and speak to that, your intervention motion is going to be much more persuasive. And it's also going to be more valuable because you're talking about impacts that would otherwise be overlooked. So that's the most important advice I can give about the things that you file in the case, is to really stick to things that you know and that you're familiar with and that you feel that are important to you. So I asked this question: will massive numbers of interventions show opposition? The PSC knows there's opposition. Let's just leave it at that. Does being a member of Stop MPRP make you a party to the case? So no. As Joanne said at the beginning, Stop MPRP is intending to intervene in this proceeding. And when Stop MPRP intervenes, it's intervening on behalf of the organization as a whole. And so as a member of the organization, you would be part of that intervention, but it doesn't make you individually a party. It's the organization that's intervening, not each individual member of MPRP. So it wouldn't make you a party just because you're a member of MPRP. That said, everything MPRP files is going to be on your behalf, and so it's going to be to your benefit. So it's still important to maintain your membership in Stop MPRP, but it's not going to make you an individual party to the case. Are comments part of the evidentiary record? So the Maryland Public Utilities Article 3-111 says that the hearing record includes evidence submitted by parties. It uses the term parties. I think that's something that we probably would at some point want to ask the PSC for clarification on. If you file comments, do they become part of the record? The other workaround is that Stop MPRP can adopt comments and move those comments into the record as an intervener. So if you participate in these public comment proceedings and you file comments, Stop MPRP can gather those comments together and make them an exhibit and submit them and make sure that they're part of the evidentiary record. if the commission is going to take a strict approach and not consider them part of the record. So just kind of to sum up the bottom line on intervention, and again, these are just broad guidelines. This is not legal advice. If you have a significant interest, if you have a business or a home or a piece of property that's going to, that's right in the eye of the fire, so to speak, you probably want to consider intervening. If it's possible the line may be rerouted on your property, you might want to consider a passive intervention. I know that also the PSC is going to be issuing guidelines on some of these issues, and so you should consider these points in light of the guidelines that the PSC is going to issue. It may answer some of these questions that you have about intervention. And if you just, again, generally speaking, if you don't have a direct interest other than general opposition, I think that your comments are, that you're better off just submitting written comments and participating through Stop MPRP rather than, trying to take up space in the process to intervene to the detriment of somebody who might be severely impacted. We had some other questions on intervention. Somebody asked if counties and municipalities could intervene. Yes, they can. It doesn't preclude them from conducting the public hearing. So you want to make sure to encourage your county, your council, or whoever is, whoever in the county has standing for intervening to intervene. If there are mayors or municipalities that can intervene, you want to encourage your elected officials and elected bodies to intervene. States usually participate as a consulting agency. They're not really interveners in the case, but they do play a very significant role in reviewing the applications and making recommendations as to whether they should be granted. Okay, so this is the process. I'm just going to have some tea. How my voice is going. So anyway. So once the application is filed, the Public Service Commission will hold a scheduling hearing. They're going to act on the interventions at the scheduling hearing. They're going to set deadlines. And this, by the way, this proceeding that the Public Service Commission is holding, it's going to be in their offices, in the hearing rooms in Baltimore, like on St. Paul Street in Baltimore. That's where they have the hearings. And they're also publicized over a YouTube channel. So if you don't want to go down to Baltimore every day, you can watch through, you can view them on YouTube. So they have the scheduling hearing and set deadlines. I guess we've been told that in this case, the Public Service Commission is not going to delegate the case to the Public Utility Law Judge. It's going to hear the case itself. So the case would be before the 5 commissioners. After the scheduling hearing, the discovery period begins. And so what discovery is in the public utilities before the Public Service Commission, it's very similar, if you're familiar with court proceedings, to discovery in a court proceeding. It gives you an opportunity to get data and information from the company and from anybody else who has filed testimony in the case. So, once the company files its application, you're going to read through it. There's going to be testimony from witnesses, from their witnesses, that is probably not supported, or probably, things that you want to ask questions about. So that all goes through filing data requests as part of discovery. The PPRP is the Power Plant Research Project. They review the application for completeness. And so there'll be a deadline set, and that's a state agency. So there's a deadline that will be set for them to do their review of the completeness of the application. There have been situations in the past where PPRP has found an application deficient, and the applicant has had to go back and provide more information before the procedure could move forward. And so that's something else that happens along the route. Once you get past that point, at some point, the interveners have an opportunity to file testimony. Then the company can file testimony to rebut the intervener's testimony. Then the interveners can file what's called surrebuttal testimony. You go back and forth with these written testimonies. After that, the Public Service Commission is going to schedule a public comment hearing. So the public comment hearing is scheduled. There's one of them is held in each county that the transmission line goes through. The county commissioners or the county council in that county can sit with the Public Service Commission to hold that hearing. And that's kind of more like a town hall meeting. people will stand up and make comments. It's not interactive. Nobody is going to respond to your comments or answer your questions. It's really just an opportunity to stand up and read your comments to the decision makers. And so that's the type of process that you have at these public hearings versus the Public Service Commission, which is going to look more like a court proceeding where you have witnesses on the stand who are being cross-examined. You have evidence that's being admitted and being verified before it's admitted into something is admitted into evidence. It's a much more formal process than the public comment process. And again, this is the hearing process. This is how it's different. The witnesses are all subject to cross-examination by the parties. The the commissioners on the PSC will also have an opportunity to ask the witnesses questions. This is a very active Public Service Commission. The commissioners are very engaged, and the hearings I've been in with this new group of commissioners it's always been a very hot bench, which is a good thing because you have the commissioner. It's good to see the commissioners engaged in trying to question the witnesses. So I was kind of guessing that the hearing could be 3 to 10 days. I know that we've had some information that's something that could be much longer than that. It's really hard to predict how long these hearings will go. It's going to depend on the number of parties, how complicated the applications are, how much cross-examination the parties have, but it's not going to be a day-long proceeding. You can count on that. And once the hearing is over, the parties get a transcript of the hearing and you file what's called a post-hearing brief. And that's where you make your arguments to the commissioners. You highlight the parts of the hearing that are most, that support your case. And you file these very lengthy, like 150-page briefs. And I'm not joking, they really are 150 pages with the commission. And then the commission will make a decision based on the factors in a Public Utilities Article 7-207. And we're going to go through what those factors are. So anyway, so the commission is going to get the briefs, and these are some of the factors that it considers when it's making a decision on the application. Let me just get my glasses on here so I can see this. Oh, wait. I just have to move. Got to move something there. So anyway, so what the commission, and this is taken right from the statute. So the commission has to, it makes a decision only after due consideration of the recommendations of the governing body of each county where the transmission line is located. So the due consideration standard, there's been a lot of case law on that. Due consideration means that the commission has to take the input from the counties very seriously. It can't just, say, we're not going to, we reject this input from the county. They have to go through all of the information that the county brings to their attention and take those recommendations into account, duly consider them. At the end of the day, though, the commission does have the ability to preempt what the counties say. So if the counties all come in and say that this transmission line should be denied, if the commission finds that there's evidence that suggests it should be granted, they can say we've given due consideration to what the counties have said, but the weight of the evidence shows that it should be approved for this and this and this reason. So the commission has to take the input from the county seriously, but at the end of the day, it can disregard it if there's other evidence in the record that suggests that what the county submitted is not supported. I just went ahead again. Wait. Okay. Okay, so some of the other things that are considered, these are things that you would assume would be considered in a CPCN proceeding. Consider the reliability of the the impact of the line on the reliability of the system, economics, aesthetics, historic sites, aviation safety, air quality and water pollution, availability of means for required disposal of waste, and the effect of climate change on transmission lines. This climate change provision was added I think in 2022, and climate change policies, Maryland has very aggressive climate change policies. And so and they take it very seriously, the effects of climate change in their proceedings. And so this is a factor that is really going to deserve a lot of consideration and discussion in this hearing. The other things the commission has to consider specific to a transmission line is the need to meet existing and future demand for electric service. They have to consider all of the alternative routes and the cost of those routes. And so if it turns out that PSEG has picked the most expensive and most environmentally damaging route, and there was a route that was cheaper, and it's not just a route that was cheaper, it could be an alternative that was cheaper too. So if the company didn't consider that, that's grounds that the commission could theoretically deny the application for. The commission will also look at whether the company is complying with PJM, with the transmission organization regulations and all of the FERC requirements. And so those are some of the factors there. It also can't approve a transmission line that's closer than a mile from an airport. So that's another factor. Now over here, the regulations talk about how the counties still have the right, if a local permit is required, they can still deny that. They still have authority to approve or deny that permit as long as the local laws are not preempted by state law. So the counties do reserve some authority, and that's why it's really important for them to be involved in these cases. And okay. Well, sorry about this. My controls are going a little crazy. So anyway, so these are some of the possible outcomes. So at any time during the case, the parties can opt to settle, to arrive at some kind of settlement. Often what a settlement might entail could be an alternative route. It could be a payout to people who are impacted. It could be mitigation of certain impacts. If all of the parties don't agree to the settlement, the company would file a contested settlement. So the people who are on board with the settlement would be in support of it, and the people who oppose it would have an opportunity to oppose it. And the commission has the authority to reject the settlement, because everything that the commission approves has to be found to be in the public interest. So if the commission believes that the settlement, even a contested settlement, is not in the public interest, it can reject it. Okay, so then once the project is approved or settled, a CPCN will issue. And at that point, eminent domain can begin, the company can initiate the process for eminent domain unless the CPCN is stayed pending appeal. So if the case is appealed, the parties who are appealing it may be able to argue to the commission that the CPCN should be stayed so that eminent domain can't move forward. It's not clear. It's impossible to predict at this point whether a stay would be granted or not. It's usually very, very difficult to get a stay, but it is an option that would slow things down. And then if a CPCN is granted, the parties can either go back to the Public Service Commission and ask them to reconsider their decision, or else they can go to one of the circuit courts, either Baltimore City Circuit Court or a circuit court where the project is located, and they can file an appeal of the CPCN. So we're going to talk a little bit about just what happens if, in the worst case scenario, if the CPCN is issued and the eminent domain process has to start. So the Maryland Public Utilities Act says that after the CPCN is issued, a person can acquire eminent domain powers for property needed for a transmission line. Now, there are some limits on eminent domain, and the next one is really important. This one is in Public Utilities Act 5-402. And what it says is there's no authorization for a corporation to take or use private property unless just compensation agreed to with the owner or awarded by a jury has been paid or tendered to the parties entitled to it or paid into the court. So the way that I read this provision is that that the company cannot take your property until you've gone to a jury to figure out what compensation is, and that amount is paid. And that's very important because there are some jurisdictions where companies have what's called a quick take right. They're allowed to go and take the property and use it and post a bond and decide on compensation after the fact. And as you can imagine, that leaves landowners leaves them with no leverage whatsoever, quite honestly, because the company can come and take your property and use it now, pay later. I mean, what can you do? You know, if you hold out for more money, they're still going to be building this thing on your property. But the way I read the Maryland statute is that until a jury awards, well, unless if you, on the one hand, you can agree to compensation and the company pays it to you, and once they've paid, they can go ahead and move forward with the project. But otherwise, the amount of payment has to be adjudicated by a jury, and so that gives you a lot more leverage in the process, because the jury taking a case to a jury can take a long time. So it might give companies more incentive to pay more, or to accede to a reroute, or to try to mitigate the impacts on your property. And I just wanted to talk about also some landowner rights in eminent domain, because I know there are some concerns that have come up with this too. So anyway, the first thing is that there's no such thing as a frivolous objection to a company's attempt to exercise eminent domain. And what I mean by that is this: you are the owner of your property. You're the presumptive owner. It's just like in a criminal defense case where somebody is presumed innocent until proven guilty. So you see in criminal defense cases, criminal defendants raise every argument under the sun to create reasonable doubt. Nobody ever accuses them of bringing frivolous claims or acting improperly, because the government has the obligation to prove every component of a criminal case. The same thing is true with eminent domain. You are presumed to be the owner of your property. The government or the utility company exercising that government power has to prove every element of its case to show that it has a right to take your property. So what that means is that you can deny access and require the company to go to court to gain access to your property. If the company wants to do a survey on it, you have no obligation to allow them access voluntarily. It's not frivolous to raise that complaint or to raise that objection, and it's not going to subject you to a lawsuit. Now, the only thing is that you have to understand that if the company does go to court and gets a court order for access, at that point you do have to allow access, or there could be contempt charges. But until the company has some sort of court order, you do not have to negotiate with them. You do not have to listen to their offers. You do not have to allow them on your property to survey. None of that until until they can show that they have a right to access by going to a court and getting an access order. Other rights that you have the right to ask for identification or proof that a representative works for PSEG if a land agent comes to your property. You can photograph what these people are doing on your property. You can follow company personnel on your property. You can't threaten them. You can't, pull out weapons on them, but you have the absolute right to photograph them, to videotape them. It's your property, and they're there as guests or as visitors. And as long as you don't interfere with the work they have to do, if for some reason they do get access to your property to conduct a survey, you can't like grab the survey tools from them or hit them over the head with a shovel, but you can videotape them and record what they're doing while they're on your property. You can call the police or the Public Service Commission to intercede if you feel that a company personnel or an agent is threatening you. If you're made an offer for compensation by the company and the company says you've got to decide right now if you're going to take it or not, you can refuse and tell them that you'd like to have your attorney review the compensation offer. And you can also have the right to ask them for a copy of any easement agreement or any company policies that are going to apply governing your use of the easement. So these are all things that you are entitled to. These are entitlements. These are not privileges that are available to you. These are entitlements that you have that give you the ability to exercise that power over the company. I know this is a big company and it's very intimidating to have them come on your property. And I know it's also, it's outrageous to be in a situation where you're viewed as the defendant in the case, in a situation where you own the property. But it's very important to understand that you do have these rights and you're entitled to them. And this is something that's protected not just by statute, but by the Maryland Constitution and the United States Constitution. So these are the highest, that your rights over your property are the highest form of rights because they're constitutionally protected. And I'm hoping that that will make you feel a little bit more confident in dealing with these people when they come on your property, and make you recognize that you have nothing to be intimidated about. The company should be ashamed of itself for taking your property. And they should be the ones who are on the defensive, not you. So that's the end of my presentation. You can get in touch with me either through here or through Joanne. She can, you can present any other additional questions you have to her, and she'll make sure that I get them. And I don't know if we have any other questions now, because I'm happy to take, to answer any questions that might be coming through.
Thank you so much. Yes, we do have some questions. I'm going to bring on our.
Okay, I'm going to stop the share.
Great. I'm bringing on our.
So you can all.
And before you get to that, Betsy, teeing one up, Carolyn, I very much appreciate the presentation, and I appreciate you sharing your number and email address. And I would just ask people to be respectful of that. She has quite a bit of work to do. And I know we have a lot of questions. It is far better for all of us to submit the questions via Stop MPRP Inc. And then we can publish those answers to everyone. We need her focused on getting ready and not answering hundreds of emails a day. So
Thank you.
yeah. Okay, Betsy.
Thank you. Allison, do you want to go ahead with the first question?
Sure, I would love to. So, Carolyn, I believe that you did already address this at a high level, but just to make sure everybody's clear, we are getting some questions around whether or not people can be individual members of Stop MPRP and still intervene individually if they would still like to. So can they still retain their membership in the organization and become a intervener if they choose to do so?
Yes, absolutely, because the intervention that Stop MPRP files will be just on behalf of the organization. It's not really going to list the members or anything like that. So it's really just an organizational intervention. And so, yes, so they can intervene in their individual capacity, provided that they've determined that they have a substantial interest that needs to be protected.
Perfect. Thank you. So we have another question too. So how does the PSC evaluate environmental justice concerns?
So the PSC will look at some of those environmental justice impacts. I have to take another look at some of Maryland's environmental justice provisions. That's a good question. I think there had been a question that came in on that. I'm not exactly sure what special attention they pay to environmental justice. It's going to depend upon what Maryland law says. But to the extent that Maryland laws are available that require consideration of impacts of projects on environmental justice, the PSC is bound to apply that. And so that's one of the things that we'll be looking at. Stop will be exploring to determine whether there are any environmental justice impacts as a result of the project, because they do. And the PSC, to the extent that it's required by law to take them into account, will take them seriously.
Fantastic. So another question that we've got is would it be beneficial for similar types of businesses, i.e. agritourism or farms in specific, to file jointly together so that they can pull resources in terms of their legal and their experts, or is that something that should be discouraged?
So that's a good question. I guess they may first want to evaluate if there are already existing organizations that represent those views, explore the extent to whether, that Stop might be addressing some of those issues in its intervention, or if there are other, chambers of commerce or other types of organizations that might be raising those issues. Otherwise, it probably is better to jointly work together to maybe, come up with the funds for like one specific expert on agritourism or something, rather than them all going in individually. That's definitely a more cost-effective way of protecting their interests. And again, the caveat would be to make sure that these businesses are actually impacted. Theoretical impacts are very different from direct and substantial direct impacts. So if some of these businesses are directly impacted, that could be a much more cost-effective way to do things if those interests aren't adequately represented through other groups already.
Fantastic, thank you. Another one that we have is, in your experience, what are some of the most common issues that you've seen that have derailed a CPCN application in the past? Is it typically due to, legal non-compliance, not following the rules, or environmental concerns? Are there some generalities as to the things that the PSC will specifically be looking at to validate the CPCN?
So it's always going to be different issues. There was one CPCN that was denied because the company that had proposed it wasn't a Maryland corporation and or it wasn't doing business in Maryland. And I think that that was a requirement. And so the application was denied for that reason, I think. And I don't know if I think the company just came back and reformed. I think some of the issues that could potentially stop a project are, at least and the laws have changed over time. I think that this particular commission takes climate change impacts very seriously. And so I think it's going to be looking very closely at climate change impacts. The other thing that's changed is that there's now some question as to the extent to which the Public Service Commission can take into account the cost of a project, of a regional project. And this is being, portrayed as a regional project. So there's been some question that has arisen as to the extent to which the PSC can take into account the cost to Maryland ratepayers of this regional project. In the past, sometimes cost issues would be the basis for denying a transmission line if it was determined that the ratepayers within a particular jurisdiction weren't getting as many benefits. But now that planning has become regional, there's some court cases that are kind of questioning the extent of a commission's authority to reject a project based on cost. But that said, I think there are other factors that the commission can look at. I mean, I think like with the choice of route, alternative routing is something that's definitely part of siting, and not just alternative routes, but alternative technologies, alternative ways of delivering this power. So I think that that's something that could potentially be a basis for denying an application if the commission finds that there was a better way to do this and the company just chose one that was more beneficial to itself rather than to ratepayers. So I think that's a strong argument too. But otherwise, the reasons these things get denied are sometimes like just really quirky, like, a company might have to get an authorization from FERC and it doesn't get an authorization and then it can't move forward, or just those kinds of things are just kind of like quirky issues like that we really would need to drill down into once we see what the application actually says. So it's hard to kind of come up with all of the arguments to focus on. But I think those alternative cost measures and the climate change issues, especially for the state of Maryland, are going to be really key issues to hone in on.
Fantastic. Along those same lines too, we did get some questions around the OPC's role, as they are, from our understanding, in charge of kind of representing the interests of the ratepayers. Where does OPC play into the PSC process?
So again, it depends on the project and it depends on the makeup of OPC at any particular juncture. I've seen cases in the past where they have been involved in challenging the costs of projects or challenging the sufficiency of an application. So OPC represents Maryland ratepayers, that's their jurisdiction. And so to the extent that this project is going to have some impact on rates or service within the state, I think that that would be something of interest to them that would prompt them to participate more extensively.
Fantastic, thank you. So we just have a couple more questions we'll try to get through. So do you recommend or suggest people that are adjacent to the line as it stands now becoming involved as an intervener, or should they hold off on filing directly?
So this is something where, as I think either Joanne said, or this is information that we have, the PSC is going to be issuing some guidance on that. And I think the guidance will probably have some recommendations for people who are adjacent. So it's probably best to at least wait for the guidance, and the guidance will certainly issue before any decisions have to be made. So that would probably be the safest thing to do at this point, is let's see what what issues the PSC comes out about that, because those are concerns that have been brought to the attention of the PSC, which, on the one hand doesn't want this proceeding to run amok, but on the other hand recognizes that, there are potential impacts when a proposal is made. So I think we'll wait to see what the PSC guidance is and then maybe return to respond to that question.
They are actively working on that and promise to have it as soon as possible. So I would expect to see that document within, a couple of days.
Okay.
I think we're about at time. I want to be mindful of everyone who joined us tonight. We said this would be an hour and we want to allow you to get back to your evenings. But Carolyn and Joanne, any final comments prior to us kind of ending our webinar tonight? And we know there are additional questions that we will work to get answers to, as always, either addressing through our online information, the newsletter, or direct contact. So please stay tuned. We'll do our very best to continue to respond to everyone's concerns and questions. But Carolyn, any final comments from you? And then we'll let Joanne wrap us up.
Yeah, I guess, like I said, my only last comment is this is a really highly controversial proceeding, and there are a lot of people who get involved from both sides and who don't necessarily have the best interests of landowners or property owners at heart. And that could be people who are philosophically opposed to like any kind of transmission line on the one side of the spectrum, and it could be, people who support the company on the other side. So it's just really important to check the source of the information that you get. Don't rely on hearsay. Don't rely on rumors. Try to check the actual statute, or, again, consult with STOP and see what materials they have to verify information that you've heard, because otherwise I've just seen terrible situations where people rely on hearsay that they've heard from a neighbor or from somebody in a particular case, and it's really to their detriment, and they wind up compromising their rights as a result. So just be sure to just take everything you hear with a grain of salt. Verify everything you hear. So that would be the advice I would have, because this is going to be very controversial, very much in the public eye. It's going to attract a lot of attention, and that is going to bring a lot of people who are not necessarily acting in your best interests.
Thank you, Carolyn. And thank you again for, making this time available and giving this webinar. There's lots of chat comments saying thank you so much. And we will gather up these other questions and try to get answers to them. I look forward to seeing everyone on Saturday for the premiere of the film. We will continue to send newsletters and try to keep folks updated as best we can. When the PSC publishes their guidance, they promise to send that to me. We'll make sure that gets out to everyone. And they also promised to let us know as soon as the application is filed. They keep saying it's not here yet, and we don't know when to really expect it, but we'll make sure we get that information out to folks as quickly as possible. And our strongest defense is locking arms and sticking together. And that's really, this group's been fabulous from the very beginning, and we need to continue to stick together and persevere through the end of, what could be another 2 years of this entire proceeding. So we need to stay strong and stay resolute and determined and work together. And I have every expectation that we will prevail in the end. Good night, everyone. Thank you.